Oh, and what is her role?
Spouse.
Spouse.
Okay, so not a victim. Okay. So you'll be able to hear what's happening, maybe not see so well, but you'll know what happens. Ready to go whenever you're set.
All right, sir. Come on over here. Step up here and state your full name to the judge.
Randall Grant Saunders.
All right, sir. What is your middle name?
Grant.
Okay, thank you. All right, sir. You're here under the authority of a warrant because you signed a complaint that you were cited and released for theft, where you promised to appear and then broke that promise and did not appear.
Yes, sir.
So that was regarding a shoplifting charge that occurred on or about February 4th of 2026. What I'd like to do is, since you failed to appear on the original court date that was scheduled for February 18th at 9 o'clock, is hold your arraignment now. To be able to do that, I have to get your consent to do this by video and waive your personal appearance. That's the only thing you'll be doing, is waiving having to come in front of me at a later date. Do I have your consent to go ahead and do that?
Yes, sir.
All right. So the Class 1 misdemeanor has a maximum fine of $2,500 plus surcharges, 6 months of jail, and or 3 years of probation. There is no mandatory minimum. There may be restitution involved. Your options are to plead guilty, not guilty, or no contest. The difference between a guilty and a no contest plea is if you plead guilty, you're admitted that you committed the crime. If you plead no contest, you're not admitting or denying the facts of the case, but acknowledging the conviction. Both guilty and no contest pleas show on a criminal history as a conviction. You also have the option to plead not guilty. If you plead not guilty, I'll schedule you for a pre-trial conference. That is where you will meet with the prosecutor, that is the attorney representing the state of Arizona. At that meeting, they may provide you the police report and share information about the case that they plan on using at a trial at a later date. One of 4 things will occur at that pretrial conference conclusion. Number 1, the case will in fact go to a trial. Number 2, the case could enter a plea agreement that all parties agree on, including yourself. Number 3, the case could dismiss. Or number 4, a continuance by either party may be granted for further collection of information. Do you understand that information?
Yes, sir.
All right. You also have the right to an attorney. So far, as of now, there is no jail time being asked of the case. So if you're asking yourself, why am I in jail? Well, that's because not of the consequences or the sentencing portion of the case. It's because you broke your promise to appear. So that's why you're in custody now. But as far as if you plead guilty or no contest, or if you're found guilty after a trial, you're not facing any jail time as of now. If that changes, so do your rights, and the court will notify you if there's any change of that. Do you understand that?
Yes, sir.
All right. So you have the right to hire an attorney at your own expense. You have the right to waive the presence of an attorney, or you have the right to ask for a court-appointed attorney at little or no cost to you. To have a court-appointed attorney, there are 2 requirements. Number 1, you must not be able to afford an attorney. Then number 2, you must have good cause. One of those examples of good cause would be if there was jail time being asked of the case. But since I informed you as of now there is not jail time, that cause is no longer available. Do you understand those options?
Sir.
Do you wish to hire an attorney, waive the presence of an attorney, or ask the court for a court-appointed attorney?
No, sir. We can't plead no contest.
Okay, so I understand you may want to plead no contest, but I need the decision about the attorney first. So you can waive the presence of an attorney if that's what you wish to do.
That's fine. Yes, sir.
Do you want me to explain the other options, or do you understand it?
I understand it.
Okay, so you do want to waive the presence of an attorney.
Yes.
Okay, so I'll be sending you a form that does two things. Number one, waives your personal appearance that I talked about in court. And number two, waives the presence of an attorney. Okay?
Yes, sir.
All right, so being that you've entered your plea of no contest, is that what I heard you want to plead?
Yes, sir.
All right, so I'm then going to schedule you for sentencing. The court must comply with victims' rights notification, so I'm going to defer your court date and give you another court date. What I now have to determine, because you've made it difficult on me by breaking your promise, is whether I should let you out of jail or not. Because you promised to come back to court last time and you didn't. If I release you, what's to guarantee you're going to show up for sentencing?
Yes, sir. I have a lot going on, and I totally forgot. It was the whole deal. I just totally forgot that I had court date. I thought it was next week, and I forgot that. It just totally slipped my mind, Your Honor.
So what you're saying is that since you were so busy before, that slipped your mind, but now that you got this fresh reminder, if I set it out about a month or 45 days, do you think you're going to get so busy that you'll forget again?
No, sir. I don't. I will not forget again.
All right. So what I do want to inform you is I'm going to go ahead and release you out of custody and set a sentencing date for you. If you miss that sentencing date, if you fail to appear and a passage of time of 90 days goes by, you lose your right to appeal any part of the case. Do you understand that?
Yes, sir.
All right. So we'll release you on your own recognizance. Your release conditions are as follows. Obey all orders of the court. Do not commit any crimes. Notify the court immediately of any change of address. Do not leave the state of Arizona without permission of the court. Do you have any questions about those release conditions?
No, sir.
All right. I will be sending your sentencing date shortly over to you, and you'll be released out of custody here within the next 15 minutes or so.
Thank you, Your Honor.
You bet.
Thanks, Judge.
You send it to you?
That's fine, yes, sir.
Okay.